Prepare for a gripping journey into the heart of British constitutional law, where the arrival of EU law ignited a high-stakes drama of sovereignty, power, and legal revolution. This isn't just history, it's a legal thriller, a political analysis, and a profound lesson in the evolution of a nation's identity. Imagine a rainy London evening in 1972. Parliament is abuzz with anticipation and trepidation. The UK, after intense negotiations, signs the European Communities Act, ushering in a new legal order. This pivotal moment, captured like a scene from a political documentary, promised unity but subtly sowed the seeds of an unprecedented constitutional conflict. EU law arrived as a formidable, supranational force, challenging centuries of legal tradition. It brought with it rules, rights, and obligations that transcended borders, compelling the UK's once insular legal system to share its authority with Brussels. This was no mere treaty, it was a paradigm shift. Direct applicability, like a foreign decree instantly becoming domestic law, EU regulations landed on judges' desks, bypassing parliamentary debate. This immediate, unmediated power was a stark departure from traditional legislative processes. Direct effect, suddenly, ordinary citizens could wield EU law in UK courts, demanding justice directly from Brussels mandates. This empowered individuals, but simultaneously underscored the diminishing exclusivity of Westminster's legislative reach. The tension escalated into a dramatic courtroom confrontation. What happens when an Act of Parliament clashes with an EU regulation? Landmark cases like Costa v ENEL and Factortame delivered a seismic verdict: EU law reigns supreme. Factortame v Secretary of State for Transport became the ultimate legal showdown. Spanish fishermen, British ministers, and legal titans clashed, culminating in a ruling that saw UK law set aside. This wasn't just a legal precedent, it was a profound redefinition of parliamentary sovereignty. Parliament, the ancient bastion of British sovereignty, recoiled. The doctrine of supremacy was a direct challenge to its authority. In Thoburn v Sunderland City Council, the metric Martyrs case, the court acknowledged the European Communities Act as a constitutional statute, not easily repealed. Yet, the underlying question lingered: could Parliament ever truly surrender its ultimate power? The people voted, triggering Brexit, a complex, high-stakes escape plan. The withdrawal agreement became the blueprint for disentanglement, a legal bridge between the old and new orders, ensuring a tumultuous transition. Retained EU law, a vast vault of EU laws was sealed and transported into the UK's legal fortress. The European Union Withdrawal Act 2018 preserved this body of law, ensuring a semblance of continuity amidst the upheaval. Assimilated Law. By 2024, this retained law was renamed and reformed as Assimilated Law, stripped of its EU interpretive features. It was a meticulous re-engineering, aiming to reclaim full legal autonomy. The UK's legal landscape is forever transformed. The Supreme Court, in cases like Lipton v BA City Flyer Ltd, grapples with whether to follow old EU case law or forge an entirely new path. Parliament debates the future of assimilated law, facing profound questions. Can a nation ever truly escape its legal past? Or do the echoes of EU law continue to shape the UK's constitutional destiny, a constant reminder of a dramatic era? Engage with this unfolding legal saga. Dive deeper into these landmark cases, debate the implications for parliamentary sovereignty, and share your insights on the UK's constitutional future. Your understanding shapes the narrative.